This is HOA citation circus. The complaint stack was identical, and that was the point. Karen held a complaint log and yelled that I was not entitled to see patterns. "I do not care what the last person did," she said, her voice bouncing off the clubhouse brick. I stood in the parking lot holding my folded invoice packet, my delivery route already 20 minutes behind, and I watched her fingers tighten around that log like she was afraid I might grab it. The overcast light made her face look sharp, every wrinkle deepening as she leaned forward. A landscaping contractor unloading mulch bags near the mailbox cluster pretended not to listen, but I saw him slow down and tilt his head. I work FedEx-style routes, which means every delay costs me money, and this delay was costing me more than money. Jennifer Howard, Welcome Committee Chair for the Willow Creek Estates HOA Board, had called me out here with a text that said she needed to discuss a compliance matter in person. I showed up expecting a 10-minute conversation about a misplaced trash bin. Instead, she handed me a pre-printed violation notice with my address on it and a date I recognized. The date matched a tow notice I had found in my mailbox 3 days earlier, a notice that claimed my vehicle was parked illegally in a guest spot overnight. The problem was, I had not parked there. I had proof. I had my route GPS logs showing I was 2 counties away that night, and I had a photo my neighbor took of my driveway with my van clearly visible. When I told Jennifer this, she did not apologize. She opened the complaint log and told me the pattern was what mattered, not individual incidents. That word, pattern, hit me wrong. I had heard it before. 6 months ago, when I first moved into Willow Creek Estates in Boulder, Colorado, I heard about a cold case. A couple who lived 2 streets over had been hit with repeated fines and tow threats for violations they swore never happened. They paid the fines, moved out, and the story died. No one followed up. The HOA management company shrugged and said the files were incomplete, but the couple had posted in the neighborhood group chat before they left, and they used that same word. Pattern. They said someone on the board was creating a pattern to justify enforcement, and they could not prove it because the records kept disappearing. I did not think about that story again until Jennifer waved the complaint log in my face and told me I was not entitled to see it. That was the moment I knew. This was not a mistake. This was the same scheme, and it was targeting me now. I am rebuilding after a move. I cannot take more disruption. My credit is clean, my savings are tight, and I have a newborn lease on this townhouse. If the HOA threatens collections language, it hits my credit before I can fight it. That deadline is real. I have maybe 2 weeks before they escalate. Jennifer snapped the log shut and told me I had 7 days to submit a written dispute with supporting evidence in the format specified in the bylaws. I asked what format. She said it was in the resident handbook. I asked where I could find the handbook. She said it was emailed to me at move-in. I checked my email right there on my phone. Nothing. She smiled and said that was my problem, not hers. "Keep talking," she said. "I love adding notes." She pulled a pen from her jacket pocket and clicked it twice, her eyes locked on mine. I decided not to say anything else. I said almost nothing, because silence makes people talk. I just stared at her and waited. She shifted her weight, glanced at the contractor, then back at me. She told me the tow company had flagged my vehicle multiple times, and the board was authorized to escalate. I asked which tow company. She said that was confidential vendor information. I asked if I could see the flagging reports. She said no. I asked if I could appeal to the full board. She said I could request a hearing, but it required a written request submitted 10 days in advance with a $50 administrative fee. I walked back to my van, unlocked it, and sat in the driver's seat with the door open. My hands were shaking. I pulled out my phone and opened the neighborhood group chat. I scrolled back 6 months until I found the posts from the couple who left. Their names were Sarah and Tom. They had posted screenshots of notices, tow warnings, and fee statements. I saved every screenshot. Then I opened my email and sent a records request to the HOA management company. I asked for all violation notices, tow authorizations, and complaint logs related to my address and the previous address tied to Sarah and Tom. I also asked for the resident handbook and the bylaws Jennifer kept referencing. I marked it urgent and copied my own email so I had a timestamp. 3 days later, the management company replied. They said my request was received, but they needed clarification on the scope. I replied with the exact same language from my first email. 2 days after that, they said they were working on it. 2 days after that, they said they could not locate some of the files. That was the first time the management company lost my dispute packet. They acted like it was my fault. I resent everything. They acknowledged receipt again. Then they went silent. Meanwhile, I got another notice. This one was taped to my front door. It said I was in violation of the landscaping maintenance standards because my front mulch bed was uneven and contained visible weeds. I went outside and looked. The mulch bed was fine. There were no weeds. I took photos. I also noticed a sticker on my mailbox post, a small orange circle that said compliance review in tiny letters. I peeled it off and photographed it. Then I saw another one on my trash bin. Then I saw one on the lamppost nearest my driveway. Someone had been marking my property. I called the management company. The woman who answered said she could transfer me to the compliance department. I waited on hold for 11 minutes. When someone picked up, it was a man who introduced himself as the property manager. I explained the situation. He listened, then told me the stickers were part of a new monitoring system Jennifer had proposed at the last board meeting. I asked if there was a board meeting where homeowners could attend. He said yes, the meetings were monthly and open to residents, but speaking time required advance sign-up. I asked how to sign up. He said I had to email the board secretary. I asked who that was. He said Jennifer Howard. That night, I sat at my kitchen table with a notebook and started mapping the case. I drew a timeline. 6 months ago, Sarah and Tom were targeted. Multiple notices, tow threats, escalating fees. They disputed, but the records were incomplete. They paid and left. Now, I was being targeted. Same tactics. Same missing records. Same person running interference. Jennifer was the welcome committee chair, which meant she was the first point of contact for new residents. She also handled compliance monitoring. She also controlled access to the board secretary role, which meant she controlled who could speak at meetings. I needed an ally. I went back to the neighborhood group chat and sent a private message to a retired police officer I had seen posting advice about HOA disputes. His name was Dennis. I explained the situation and asked if he had time to talk. He replied within an hour and said he would meet me at the coffee shop near the clubhouse the next morning. Dennis showed up with a file folder and a thermos. He sat across from me, opened the folder, and pulled out a printed copy of Colorado HOA law. He tapped a section about records access and said every homeowner has the right to inspect HOA records within a reasonable time, and the board cannot charge more than the actual cost of copying. He also said if the board is selectively enforcing rules, that is a violation of the governing documents and it opens them up to liability. He asked if I had proof of selective enforcement. I showed him the screenshots from Sarah and Tom, the notices I had received, and the photos of the stickers. He leaned back and said this looked like a pattern case, and pattern cases usually meant someone on the board had a personal agenda or was covering up financial mismanagement. That word, financial, made me stop. I asked what he meant. Dennis said sometimes board members create fake violations to justify fines, and the fines go into the HOA operating account, and the board uses that money to cover budget gaps or pay for unauthorized expenses. He said it was rare, but it happened. He said if I wanted to investigate, I should request the HOA financial statements and compare the fine revenue line to the number of actual violations on file. If the numbers did not match, that was a red flag. I sent another records request that afternoon. This time I asked for the last 2 years of financial statements, the fine and fee schedule, and a list of all violations issued in that period with dates and addresses. I also asked for the minutes from every board meeting in the last year. I marked it urgent and copied Dennis. The management company replied the next day. They said the financial statements required board approval to release, and the board would review my request at the next meeting. I asked when the next meeting was. They said 3 weeks. I replied and said Colorado law requires records access within a reasonable time, and 3 weeks is not reasonable. They said they would escalate my request. Then they went silent again. That weekend, I got a call from a tow company. The driver said he was on site at Willow Creek Estates, and he had authorization to tow my vehicle for repeat parking violations. I told him I was standing in my driveway and my vehicle was in my driveway. He said his paperwork showed a different address. I asked him to read the address. He did. It was my address. I asked him to look at my driveway. He paused, then said he would call his dispatcher. I waited on the line. I heard him talking to someone in the background. Then he came back and said the authorization was confirmed and he was proceeding. I told him I had proof I was not in violation, and I would file a complaint with the police if he hooked my vehicle. He hesitated. He said he would call his dispatcher again. While I waited, I saw Jennifer walking toward my driveway from the direction of the clubhouse. She was holding her phone and a clipboard. She stopped at the curb and called out to the tow driver. She said the authorization was valid and he needed to proceed immediately. The driver looked at me, then at her, then at his clipboard. He said he was waiting for dispatch. Jennifer said she was the welcome committee chair and she had issued the authorization herself, and if he did not proceed, she would report him to his company. The driver said he needed to follow his company protocol. Jennifer raised her voice and said this was the 3rd time this resident had violated parking rules, and the HOA had a contract with his company, and if he did not do his job, the contract would be reviewed. I walked closer and said I had GPS logs, photos, and witness statements proving I was not in violation. I also said I had filed a records request showing the HOA had issued multiple false notices, and if the tow proceeded, I would file a police report for theft and fraud. The driver looked at Jennifer, then at me, then at his clipboard again. He said he was going to call his supervisor. Jennifer said she would call the supervisor herself. She pulled out her phone and started dialing. The driver raised his hand and said he was not proceeding until he had confirmation from his supervisor and law enforcement if necessary. Jennifer froze. Her face went red. She said, "Go ahead and call whoever you want, I have a committee for that." The driver called his supervisor. I called Dennis. Dennis showed up 10 minutes later with a printed copy of the Colorado towing statute and a notepad. He introduced himself to the tow driver as a retired officer and asked to see the authorization paperwork. The driver handed it over. Dennis read it, then looked at Jennifer. He said the paperwork listed 3 prior violations, but did not include dates, photos, or descriptions. He said under Colorado law, a tow authorization for repeat violations requires documentation of each prior incident, and without that documentation, the tow is not legally supported. He said if the driver proceeded, the HOA and the tow company could both be held liable for wrongful towing. Jennifer started talking fast. She said the documentation was on file with the management company, and Dennis was not authorized to review it because he was not a board member. Dennis said he did not need to be a board member to know the law, and the driver was the one who needed to see the documentation before proceeding. The driver said he was not proceeding. He packed up his clipboard, walked back to the truck, and drove away. Jennifer stood on the curb staring at me. "Keep talking," she said. "I love adding notes." Then she turned and walked back toward the clubhouse. That night I got an email. It was from the HOA management company, and it was addressed to all residents. The subject line said compliance update. The email said the board had identified several residents who were refusing to follow community standards, and those residents were creating safety and property value concerns for the neighborhood. It said the board was committed to upholding the governing documents and would take all necessary enforcement actions, including fines, liens, and legal proceedings. It did not name anyone, but the next morning, 3 neighbors texted me to ask if I was okay. One of them forwarded a screenshot from a private neighborhood Facebook group I was not part of. The screenshot showed a post from Jennifer. The post said there was a resident on Maple Court who had been flagged for multiple violations and was now interfering with HOA enforcement efforts and threatening vendors. It said the resident was creating a hostile environment and other homeowners should be aware. My address was not in the post, but Maple Court was my street, and I was the only person on Maple Court who had been in a public dispute with Jennifer. I forwarded the screenshot to Dennis. He replied within minutes. He said that was defamation and harassment, and if Jennifer had posted it in her capacity as a board member, the HOA could be held liable. He said I should document everything and consider filing a complaint with the Colorado HOA office and possibly a civil suit. He also said I should request an emergency board hearing to address the false statements and the selective enforcement pattern. He said emergency hearings were allowed under the bylaws if a homeowner could show immediate harm, and this email blast qualified. I drafted a formal hearing request that night. I cited the false notices, the tow attempt, the public shaming email, and the Facebook post. I said I had evidence of a pattern targeting me and at least one prior resident, and I was requesting an emergency hearing to present that evidence and demand corrective action. I also said I was requesting the immediate suspension of all fines and enforcement actions related to my property until the hearing was concluded. I sent the request to the management company, the full board distribution list I had found in the bylaws, and Dennis as a witness. I marked it urgent and requested a hearing within 7 days. The management company replied the next morning. They said emergency hearings required a majority board vote to approve, and the board would vote at the next regular meeting. I replied and said the bylaws allowed any board member to call an emergency meeting with 48 hours notice, and I was requesting that a member do so. They said they would forward my request. Then they went silent. 2 days later, I got a new notice. This one was taped to my front door again, but it was different. It was printed on HOA letterhead, and it had a date and timestamp that said it was issued 4 days earlier. The violation was for an unapproved exterior modification, specifically a doorbell camera I had installed 2 weeks after moving in. The notice said I had failed to submit an architectural review application, and the camera had to be removed within 72 hours or I would be fined $200. The problem was, I had submitted an application. I had submitted it through the online portal the same day I installed the camera. I had a confirmation email with a timestamp. I checked the portal. My application was gone. It was not marked approved or denied. It was just gone. I called the management company. I got the same property manager. I explained the situation. He said he would look into it. I asked him to check the portal logs to confirm my application was submitted. He said the portal did not keep logs. I asked how that was possible. He said it was a third-party system and they did not have access to back-end data. I asked if he could confirm with the board that my application was received. He said the board reviewed applications monthly, and my application would have been reviewed at the last meeting if it was submitted. I asked if I could see the meeting minutes. He said the minutes were not finalized yet. I asked when they would be finalized. He said usually within 30 days. I asked if I could get a copy of the architectural review log showing all applications submitted and reviewed. He said that would require a records request. I said I had already submitted 2 records requests and I was still waiting. He said he would escalate. That afternoon I got a text from Dennis. He said he had checked with a friend who worked in HOA management in another city, and the friend said disappearing portal applications were a red flag for either technical incompetence or deliberate records tampering. He said if I wanted to prove tampering, I needed to get a forensic audit of the portal, but that would require a board vote or a court order. He also said I should file a complaint with the Colorado Division of Real Estate, which regulates HOA management companies, and report the missing records and the retaliation pattern. I filed the complaint that night. I attached the screenshots, the email blast, the Facebook post, the notices, the tow attempt documentation, and the confirmation email for my doorbell camera application. I also attached the records requests and the management company responses showing the delays and missing files. I marked it as a retaliation and fraud case. The complaint system said I would get a response within 15 business days. The next morning, I got a call from an unknown number. I answered. It was a woman who said she was calling from the law firm that represented the Willow Creek Estates HOA. She said the board had received my hearing request and they were willing to schedule a hearing, but they wanted to resolve the matter informally first. She said, if I withdrew my hearing request and agreed to remove the doorbell camera and pay the outstanding fines, the board would close the case and remove the violations from my record. I said I was not paying fines for violations that did not happen, and I was not removing a camera I had approval to install. She said I did not have approval. I said I had a confirmation email. She said the confirmation email was not an approval, it was just a receipt. I said that was not what the portal instructions said. She paused, then said the board was prepared to proceed with enforcement, including filing a lien if necessary. I said I would see them at the hearing. She said the hearing had not been approved yet. I said the bylaws required a response within 7 days, and if the board did not approve it, I would file a complaint with the state and possibly a lawsuit for violation of the governing documents. She said she would relay my position to the board. Then she hung up. 2 days later, the board approved the emergency hearing. The notice came via email. The hearing was scheduled for the following Tuesday at 6 p.m. in the clubhouse conference room. The notice said I would have 10 minutes to present my case, and the board would deliberate and issue a decision the same night. It also said I could bring one witness, and all evidence had to be submitted in advance. I forwarded the notice to Dennis and asked if he would be my witness. He said yes. Then I started preparing. I printed everything. I printed the screenshots from Sarah and Tom. I printed my notices. I printed the tow attempt documentation. I printed the email blast. I printed the Facebook post. I printed the confirmation email for the doorbell camera. I printed the records requests and the management company responses. I printed the financial statements I had finally received after my third request, which showed a line item for fine revenue that was 3 times higher than the number of documented violations. I printed the Colorado HOA law sections Dennis had highlighted. I put everything in a binder with tabs and color-coded sticky notes labeled by dates. The binder became my signature prop. I carried it everywhere. I brought it to the coffee shop when I met Dennis to go over the presentation. I brought it to the clubhouse the day before the hearing to confirm the room setup. I brought it to my van when I went back to work, because I did not trust leaving it at home. The binder was my proof, and the proof was the only thing that mattered. Monday night, the night before the hearing, I got a new email from the management company. The subject line said hearing postponement. The email said the board had reviewed my evidence submission and determined that additional time was needed to investigate my claims. The hearing was postponed to the following month. I replied immediately and said the bylaws did not allow postponements without homeowner consent, and I did not consent. I also said the postponement was retaliation, and I would file an additional complaint. The management company replied and said the board had the authority to manage its meeting schedule, and the postponement was final. I called Dennis. He said the postponement was a stalling tactic, and it meant the board was worried. He said I should show up at the clubhouse at the original hearing time anyway and demand to be heard. He said if the board refused, that was another violation, and it would strengthen my case if I ended up in court or arbitration. He also said I should bring a witness who could document the refusal. He said he would be there. Tuesday at 6 p.m., I walked into the clubhouse with Dennis and the binder. The conference room was dark. The door was locked. There was a printed sign taped to the door that said meeting canceled. I took a photo of the sign. Then I knocked. No answer. I called the property manager. He did not pick up. I called the board president, whose number I had found in the bylaws. She picked up on the third ring. I said I was at the clubhouse for the emergency hearing, and the room was locked. She said the hearing was postponed, and I had been notified. I said I did not consent to the postponement, and I was demanding to be heard. She said the board was not required to hold a hearing if it determined additional investigation was needed. I said the bylaws required a hearing within 7 days of an emergency request. She said she would discuss it with the board attorney. Then she hung up. Dennis and I stood in the hallway for 10 minutes. No one came. Finally, Dennis said we should leave and document everything, because the refusal to hold the hearing was a violation, and it would matter later. We walked out. In the parking lot, I saw Jennifer sitting in her car near the clubhouse entrance. She was on her phone. When she saw me, she rolled down her window and said the board had every right to postpone a hearing if new information came to light. I asked what new information. She said that was confidential. I asked if she was on the board. She said she was the Welcome Committee chair, and the Welcome Committee reported to the board. I asked if the Welcome Committee had the authority to cancel hearings. She said she did not cancel anything, the board did. I asked if she advised the board to cancel. She smiled and said, "Keep talking, I love adding notes." If you are enjoying this story, hit that like button and subscribe for more wild HOA drama. That night, I wrote an email to the full board. I said the refusal to hold the hearing was a violation of the bylaws and Colorado law, and I was requesting an immediate meeting with the board attorney and the full board to resolve the matter. I also said I was filing a formal complaint with the Colorado Division of Real Estate for retaliation, records tampering, and failure to follow governing documents. I attached the photo of the locked door and the canceled sign. I sent the email at 11 p.m. and copied Dennis and the management company. The next morning, I got a reply from the board attorney. Her name was Laura. She said the board had reviewed my claims and determined that the postponement was appropriate given the complexity of the case. She said the board was committed to a fair process, and the rescheduled hearing would provide ample time for both sides to prepare. She also said my repeated accusations of retaliation and fraud were unfounded and potentially defamatory, and if I continued to make those accusations publicly, the board would consider legal action. She said the rescheduled hearing was set for 4 weeks from the original date, and I would receive a formal notice within 48 hours. I forwarded the email to Dennis. He called me immediately. He said the legal threat was a pressure tactic, and it meant the board was panicking. He also said 4 weeks was too long and I should push back. He said I should file a motion with the county court to compel the HOA to hold the hearing within the original 7-day window. He said the motion would cost a filing fee, but it would put the board on the defensive and force them to explain the postponement to a judge. He also said I should request a temporary restraining order to stop any enforcement actions until the hearing was held. I filed the motion the next day. I attached the bylaws, the hearing request, the postponement email, the photo of the locked door, and the attorney email. I requested a hearing within 14 days and a restraining order stopping all fines, liens, and enforcement actions. The filing fee was $150. The clerk said I would get a hearing date within 10 business days. 3 days later, I got a new notice. This one was delivered by certified mail. It was a formal violation notice for failure to remove the doorbell camera, and it included a $200 fine and a warning that additional fines of $50 per day would accrue if the camera was not removed within 5 days. The notice was dated 1 week earlier. It had been backdated. I compared the postmark on the envelope to the date on the notice. The postmark was from yesterday. The notice was dated 8 days ago. I photographed everything. Then, I called Dennis. Dennis said backdating a notice was fraud, and it was also evidence of tampering. He said I should file a police report immediately and bring the envelope in the notice as evidence. He also said I should add the backdated notice to my court motion as proof that the HOA was retaliating and escalating despite my legal action. He said the judge would not like that. I filed the police report that afternoon. The deputy who took the report was skeptical at first. He said HOA disputes were civil matters and the police usually did not get involved. I showed him the backdated notice and the postmark. I also showed him the binder and explained the pattern. I told him about Sarah and Tom, the missing records, the tow attempt, the email blast, and the canceled hearing. I said I had evidence that someone on the board was creating false violations to justify fines, and the backdated notice was proof of intent. The deputy looked at the binder, then at the notice, then at me. He said he would file the report and forward it to the fraud unit, but he could not promise they would investigate. He also said I should keep documenting everything, because if this went to court, the documentation would matter. He gave me a case number. That case number became my trump card. A police incident number from a prior HOA trespass attempt that shows a pattern. I did not tell anyone I had it, not even Dennis at first. I just kept it in my back pocket and waited for the right moment. The court hearing was scheduled for 2 weeks later. In the meantime, the HOA escalated again. They sent a second email blast to all residents. This one said the board had identified a resident who was filing frivolous complaints and wasting HOA resources, and the board was considering imposing additional fees on that resident to cover legal costs. It did not name me, but it said the resident lived on Maple Court and had filed multiple complaints with outside agencies. Every neighbor on my street knew it was me. I got texts from 4 neighbors that night. 2 of them were supportive. They said they had also had problems with Jennifer and they believed me. One of them said they had been hit with a fake violation for an unapproved fence color, even though the fence was the same color as everyone else on the block. The other said they had been threatened with a tow for parking in their own driveway because Jennifer said the driveway extension was not approved, even though it had been there for 5 years. The other 2 texts were hostile. One said I was making the neighborhood look bad and I should just follow the rules. The other said I was costing everyone money with my complaints and I should move if I did not like the HOA. Dennis said the hostile texts were a sign that Jennifer was working the rumor mill, and I should expect more of it. He also said the email blast about legal fees was a direct threat, and I should add it to my court motion. I did. The weekend before the court hearing, I got a call from the board president. She said she wanted to talk off the record. I said I was recording the call. She paused, then said she was calling because the board attorney had advised the board that my court motion had merit, and the board was at risk of losing if the case went forward. She said the board was willing to drop all fines and violations related to my property and approve my doorbell camera if I withdrew the motion and agreed not to file any more complaints. I said I wanted the approval in writing signed by the full board, and I wanted a written apology for the false notices and the public shaming. She said the board would not apologize. I said then we would see the judge. She said I was making a mistake. I said I would take my chances. She hung up. Monday morning, I walked into the county courthouse with Dennis, the binder, and a printed copy of my motion. The hearing was in a small courtroom on the 3rd floor. The judge was a woman in her 50s who looked tired. The board was represented by Laura, the attorney. Laura was alone. No board members showed up. The judge asked Laura why the board had postponed the emergency hearing. Laura said the board needed additional time to investigate the homeowner claims. The judge asked what investigation was required. Laura said the board was reviewing records and consulting with the management company. The judge asked if the records review was complete. Laura said not yet. The judge asked how long it would take. Laura said at least 2 more weeks. The judge looked at me. She asked if I had evidence that the postponement was retaliatory. I said yes. I handed the clerk a copy of the backdated notice, the postmark envelope, the email blasts, and the Facebook post. The judge reviewed them. She asked Laura if the board had issued a backdated notice. Laura said she was not aware of any backdated notice. The judge held up the envelope and the notice and pointed out the date discrepancy. Laura said that could be a clerical error. The judge asked if the board had a pattern of clerical errors. Laura did not answer. The judge said the postponement appeared to be retaliation, and the board was ordered to hold the emergency hearing within 7 days. She also granted a temporary restraining order stopping all fines and enforcement actions until the hearing was concluded. She told Laura the board was on thin ice, and if there were any more delays or retaliation, she would consider sanctions. Laura nodded. I walked out of the courthouse with Dennis. We stood in the hallway outside the courtroom. Dennis said the judge had handed me a win, and the board was now in full panic mode. He said I should expect them to try to settle before the hearing, and I should not settle unless I got everything I wanted. He also said I should be ready for the board to bring reinforcements to the hearing, including expert witnesses or more attorneys. He said I should bring more evidence. I spent the next 5 days gathering more evidence. I went back through the neighborhood group chat and found posts from 3 other residents who had complained about false violations in the last year. I reached out to all of them. 2 responded. One was a retired teacher named Linda, who said she had been hit with a fine for an unapproved holiday decoration, even though the decoration was a wreath that matched the HOA guidelines exactly. She said she paid the fine because she did not want to fight. The other was a software engineer named Greg, who said he had been threatened with a lien for unpaid fines related to a trash bin violation, even though he had proof he had paid the fines. He said the management company eventually admitted the payment had been misapplied, but they never apologized. I added their stories to the binder. I also printed the HOA fine revenue financial statements and highlighted the discrepancies. The fine revenue for the last 2 years was $47,000. The documented violations on file totaled 23. If every violation resulted in a $200 fine, the total revenue should have been $4,600. The difference was over $42,000. Either the HOA had issued hundreds of undocumented violations, or someone was inflating the revenue numbers. Either way, it was a red flag. The night before the rescheduled hearing, I got a call from Laura, the board attorney. She said the board wanted to make one final settlement offer. She said the board would drop all fines, approve the doorbell camera, and issue a written statement clarifying that I was not in violation of any rules. In exchange, I would withdraw my court motion, my division of real estate complaint, and agree not to discuss the case publicly. I said I wanted the statement to include an acknowledgement that the notices were issued in error. She said the board would not admit error. I said then I would see them at the hearing. She said the board was prepared to present evidence that I had been in violation, and I should be prepared for the board to defend its actions. I said I was prepared. She hung up. The next night, I walked into the clubhouse conference room at 5:45 p.m. The room was set up with a long table at the front for the board and rows of chairs facing the table for residents. Dennis was already there, sitting in the back row. I sat next to him. At 6 p.m. the board filed in. There were 5 board members, including the president, and Laura the attorney. Jennifer was not on the board, but she was sitting in the front row on the side, holding a clipboard. The president called the meeting to order and said we were here to address my emergency hearing request. She said I would have 10 minutes to present my case, and then the board would ask questions and deliberate. She said the board had also prepared a response, and Laura would present it after my presentation. She asked if I was ready. I said yes. I stood up and walked to the front of the room. I opened the binder and started. I said I was here because the HOA had issued multiple false violations against my property, attempted to tow my vehicle without legal basis, publicly shamed me in email blasts and social media, backdated enforcement notices, and obstructed my access to records. I said I had evidence that this was not an isolated case, but part of a pattern targeting multiple residents. I said the pattern suggested either gross incompetence or deliberate fraud, and the financial records supported the fraud theory. I walked the board through the timeline. I showed them the screenshots from Sarah and Tom. I showed them the notices I had received. I showed them the tow attempt documentation and the statement from the tow driver. I showed them the backdated notice and the postmark envelope. I showed them the email blasts and the Facebook post. I showed them the missing portal application and the confirmation email. I showed them the financial statements and the revenue discrepancy. I said the HOA had collected over $42,000 in fines that were not tied to documented violations, and I wanted to know where that money went. The room was silent. I looked at the board. The president looked at Laura. Laura looked at her notes. Jennifer was writing on her clipboard. I kept going. I said I had also filed a police report for fraud, and I had a case number. I held up the police report. I said the case was under review, and if the board continued to retaliate or obstruct, I would request a criminal investigation. I said I was not asking the board to admit wrongdoing tonight. I was asking the board to stop the enforcement actions, refund the fines, and commit to transparent records access and fair enforcement going forward. I said if the board did not agree, I would proceed with my court motion and my state complaint, and I would also file a civil suit for defamation and harassment. I sat down. The president asked if I had anything else. I said no. She asked Laura to present the board response. Laura stood up and said the board had reviewed my claims and found them to be largely based on misunderstandings and procedural errors. She said the notices I had received were valid, and the violations were documented in the HOA files. She said the tow attempt was authorized based on reports from other residents, and the fact that the tow did not proceed did not mean the authorization was invalid. She said the email blasts were informational and did not target me specifically. She said the backdated notice was a clerical error and the board had corrected it. She said the financial discrepancy was due to a reporting error and the management company was working to reconcile the accounts. She said the board had acted in good faith throughout, and my accusations of fraud and retaliation were unfounded. Laura sat down. The president asked if the board had any questions for me. One board member, a man in his 60s, raised his hand. He asked if I had proof that the violations were false, or if I was just disputing the board interpretation of the rules. I said I had proof. I pulled out the GPS logs, the photos, and the witness statements. I walked him through each violation and showed him why it was false. He nodded and said he would review the documents. Another board member, a woman in her 40s, asked if I had contacted the management company before filing complaints with outside agencies. I said yes. I had filed 2 records requests and multiple dispute submissions, and the management company had lost my documents twice and delayed my requests for weeks. She asked if I had proof of that. I said yes, and I handed her the email chain. The president said the board would deliberate. She asked everyone except the board and Laura to leave the room. I walked out with Dennis. We stood in the hallway. Jennifer walked past us without making eye contact. I could hear voices inside the conference room, but I could not make out words. After 15 minutes, the door opened. The president called me back in. I sat down. The president said the board had reviewed my evidence and the board response, and the board had decided to take the following actions. First, the board would drop all fines and violations related to my property. Second, the board would approve my doorbell camera application retroactively. Third, the board would direct the management company to complete my records requests within 7 days. Fourth, the board would conduct an internal audit of the fine revenue and enforcement records to identify any discrepancies. Fifth, the board would issue a written statement to all residents clarifying that enforcement actions must be based on documented violations and that residents have the right to dispute violations through a fair process. She paused. She said the board would not issue an apology because the board believed it had acted in good faith. She also said the board expected me to withdraw my court motion and my state complaint in exchange for these actions. I said I would withdraw the court motion, but I would not withdraw the state complaint until the audit was complete and the results were made public. She said that was not acceptable. I said those were my terms. She looked at Laura. Laura whispered something. The president said the board would agree to my terms if I also agreed not to file any additional complaints unless new violations occurred. I said I agreed. The president said the board decision was final. She asked if I had any questions. I said yes. I asked if Jennifer Howard would be removed from her role as Welcome Committee Chair, given her involvement in the enforcement pattern. The president said that was a personnel matter and would be addressed separately. I asked if the board would commit to publishing enforcement standards and timelines to all homeowners to prevent future selective enforcement. She said yes, the board would include that in the written statement. I said thank you. I walked out of the conference room with Dennis. In the hallway, I saw Jennifer standing near the exit. She was on her phone. When she saw me, she ended the call and walked over. She said I had made a lot of noise for nothing, and the board was just trying to avoid a lawsuit. I said the board was trying to avoid a fraud investigation. She said I had no proof of fraud. I pulled out my phone and opened my email. I showed her the screenshot of the police report with the case number. I said I had proof, and the police had proof, and if she kept pushing, I would make sure the investigation expanded to include her personally. Her face went pale. She said she had done nothing wrong. I said the backdated notice had her signature on it. She said that was a clerical error. I said the email blast had her name in the metadata. She said she did not write that email. I said the Facebook post came from her account. She said someone must have hacked her account. I said the police could subpoena her account records and find out. She stepped back. She said I was bluffing. I said try me. Dennis stepped between us. He said we were done here, and Jennifer should walk away before she said something she regretted. Jennifer looked at him, then at me, then turned and walked out. Dennis said that was the moment she knew she had lost. 2 days later, I got an email from the board president. The email said the board had completed a preliminary review of the enforcement records, and the review had identified several inconsistencies. The email said the board had decided to suspend Jennifer Howard from her role as Welcome Committee Chair pending a full investigation. The email also said the board had hired an independent auditor to review the fine revenue and enforcement records, and the results would be shared with all homeowners within 60 days. The email said the board apologized for any confusion or inconvenience caused by the inconsistencies, and the board was committed to fair and transparent enforcement going forward. I forwarded the email to Dennis. He replied with one word: victory. 3 weeks later, the independent auditor released the report. The report found that the HOA had issued 127 violations over the last 2 years, but only 23 were documented in the official files. The missing 104 violations were either never formally issued, or the records were deleted or lost. The report also found that the fine revenue was overstated by $38,000, and the excess revenue could not be traced to documented violations. The report recommended that the HOA refund all fines tied to undocumented violations, implement a new records management system, and provide annual enforcement training for all board members and committee chairs. The report also included a section on Jennifer Howard. The section said Jennifer had issued 89 of the 104 missing violations, and 67 of those violations were issued to residents who had filed complaints or disputed prior violations. The section said the pattern suggested selective enforcement and possible retaliation. The section recommended that Jennifer be permanently removed from any HOA leadership role. The board held an emergency meeting the next week. The meeting was open to all residents. I attended. So did Dennis, Linda, Greg, and about 30 other neighbors. The board president read the auditor report aloud. Then she said the board had voted to accept all of the auditor recommendations. She said Jennifer Howard had been removed from the Welcome Committee, and the board would not appoint her to any other committee or leadership role. She also said the board would refund all fines tied to undocumented violations, and the refunds would be issued within 30 days. She said the board would publish enforcement standards and timelines to all homeowners, and the standards would be posted on the HOA website and included in the next newsletter. Then she said the board had one more action to take. She said Jennifer Howard had been asked to attend the meeting to apologize on the record in front of the room, and Jennifer had agreed. Jennifer walked to the front of the room. She looked at the floor. She said she was sorry for any confusion or mistakes she had made as Welcome Committee Chair, and she had tried to do her best for the community. She said she never intended to target anyone unfairly. The room was silent. The president thanked her and said the apology was noted. Jennifer walked out. After the meeting, I stood in the parking lot with Dennis. He said I had won, and the win was bigger than I expected. He said the refunds would help other residents, the new standards would protect future residents, and Jennifer would never have power in the HOA again. I said it felt like justice. He said it was. 1 week later, I got a check in the mail from the HOA. The check was for $850, the total of all the fines I had been charged. I deposited it. I also got a letter from the Division of Real Estate. The letter said they had completed their investigation of my complaint, and they had found that the management company had failed to maintain adequate records and had delayed my records requests in violation of Colorado law. The letter said the management company had been fined $2,500 and required to implement new records retention policies. The letter said my complaint was closed. That night, I updated the neighborhood group chat. I posted a summary of the auditor report, the board actions, and the refund process. I also posted a reminder that residents have the right to dispute violations, request records, and demand fair enforcement. I said if anyone else had been targeted by false violations, they should contact the board and request a refund. I said I was happy to help if anyone needed advice. I got messages from 6 neighbors that night. 3 of them said they had also received refunds. 2 said they were going to request refunds for old fines. 1 said thank you for standing up and fighting. A month later, I saw Jennifer at the grocery store. She was in the produce section. She saw me and turned away. I did not say anything. I just kept shopping. That was enough. The HOA is different now. The board publishes meeting minutes within a week. The enforcement standards are clear and posted online. The records requests are answered on time. The fine revenue line in the financial statements matches the documented violations. The system works. I still carry the binder in my van. I probably do not need it anymore, but it reminds me that proof matters, that silence makes people talk, and that even a small fight can change a broken system. Document everything, and I will see you soon.